The CFTC continues its deregulatory agenda by issuing a no-action letter for credit default swaps, which were the subject of the movie The Big Short and one of the causes of the Great Financial Crisis. So a couple of days ago, this letter was issued by the Market Participants Division concerning commodity pool operator registration, and it was issued to the Structured Finance Association, which is an industry trade group composed of many banks. There are lots of ways to take obligations and shift them over to a special purpose vehicle and sell them to investors. I did a video recently on rated note feeder funds, so you can check that out if you like, but this is very simple, so it's not as complicated as that. So if you watch the movie The Big Short, you might recognize term credit default swaps, and here's the concept. You have the seller, in this case the banks. The bank has these pool of assets. Let's say that they're impaired commercial loans and they want protection on them. So a seller is willing to offer them protection on this, insurance, credit default, however you want to term it. And the bank makes periodic payments this way. And if something happens to these, they get impaired, then the seller of the protection will have to pay the bank to make them whole. And unlike in The Big Short with Michael Burry, where you had one buyer going against the bank, in this case, the bank itself is creating the SPV, and then they're selling this to people. And in exchange for the periodic payments from the bank, this SPV will indemnify the bank if these assets get impaired. So why would the bank do that? Well, if you have these on the balance sheet and something goes wrong, those losses could imperil the bank. So by creating this special purpose vehicle, which has guaranteed insurance payments in the form of a credit default swap, the bank's risk profile, their required net capital, things like that, are a lot more favorable. So a bank takes in deposits and makes out loans. And when it has money, it can buy certain assets and it gets credit for those as net capital. For cash, you get 100 cents on the dollar. For marketable securities like stocks, you get a lot less. And with these loans, you get better regulatory treatment if you've hedged them than if you haven't. So that is the purpose for them creating this special purpose vehicle and trying to market it to investors so that any losses from this will be the problem of the SPV and the people who invested in it. It won't be the bank's problem. So why is the CFTC involved? Well, if you remember from The Big Short, part of the reason that these were so damaging to the economy is that banks were doing a ton of them and they were completely unregulated. So prior to the Great Financial Crisis, if you looked at the Commodity Exchange Act, there was a section that excluded these types of swap transactions from the CFTC's jurisdiction. And because banks and insurance companies were engaging in these credit default swaps, selling insurance, and these weren't cleared through anyone, the problem got very large very quickly. So after the Great Financial Crisis, Congress decided that these should be regulated by a financial regulator. They looked at the CFTC and they looked at the SEC, and because the SEC had been tainted by recent scandals such as Enron and Bernie Madoff, and because ultimately they had jurisdiction over many of the financial institutions that went under, they were not trusted, and Congress gave the majority of authority over these types of transactions to the Commodity Futures Trading Commission because they thought that these transactions were too dangerous to be unsupervised. And this no action letter seems to go the other way and revert it to the pre-financial crisis Michael Burry Big Short treatment. So because they're taking all these obligations and they're putting it together and they're selling credit default swaps on them between the bank and the special purpose vehicle, that looks like a commodity pool. And rather than complying with the rules for commodity pools regarding disclosure and registration and everything like that, they wrote in for relief, which was granted. And so they're allowed to engage in these types of transactions without registering as a commodity pool or being subject to those regulations, as long as they don't market them as a commodity pool or a method of investing in swaps. And the reason that a no action letter is issued is when something that you're doing violates the Commodity Exchange Act or the Commission's rules, and you'd like to do it anyway because the rules don't apply to your particular situation, then sometimes you get this no action relief. And in this case, it's pretty clear that what they're doing would make them commodity pools and would subject them to the CFTC's jurisdiction and the rules about commodity pools. So the CFTC issued this letter, which said that even if you do exactly what you're doing, and that would normally require registration and complying with the rules, we're not going to recommend enforcement do anything to you, and that's what a no action letter does. And no action letters with the CFTC are different than no action letters with the SEC. In the SEC, when they issue a no action letter, like they recently did with Fuse Crypto, those no action letters apply to other people who are similarly situated with the same fact pattern. So if the SEC issues a no action letter for somebody, anyone else with the same situation can rely on it. So for instance, there's something called an Exxon Capital transaction that was issued decades ago to a company called Exxon Capital. And it's one of the most widely used capital raising tools out there. And everyone uses it, and they don't write in for no action relief because you can rely on somebody else's no action at the SEC if you have the same fact pattern. But at the CFTC, each person needs their own no action letter unless there's a request by a industry group such as this. And when that is the case, they issue what is called a global no action. And instead of each person needing their own relief, as long as you meet the same fact pattern, you can rely on this. So for now, financial institutions such as banks and everything that want to do these credit shifting transactions where you have these assets on your balance sheet and you don't want take the risk of them being impaired, or you want better capital treatment, you can transfer them to the special purpose vehicle and then have people invest in the special purpose vehicle. And because there is a credit default swap shifting risk to the special purpose vehicle, it moves the risk off your balance sheet to the special purpose vehicle. And as I said, if this sounds a lot like The Big Short and the Great Financial Crisis, made famous in the movie with Michael Burry, that's exactly what it is. So anyway, if you have questions about this, just leave it below. And if there's other videos you'd like to see, just drop a comment. And because I'm a lawyer, I'll give you the disclaimer. Although I'm a lawyer, I'm not your lawyer, and nothing I've said here creates an attorney-client relationship between you and I. This is for educational and informational purposes only, and if you have specific facts and questions about your specific circumstances, you should take them up with your own legal counsel. So my name's Pete. I'm an attorney with 25 years experience in the financial markets. And if you'd like to work with me either on a consulting or legal basis, you can contact me on this website or through my other website, turnkeyfamilyoffice.com. Have a great day, everyone.